Welcome to another episode of The Dissection. Jacob Zuma is back in court today, and he is back in court for what is going to be the biggest fight of his life, the biggest legal fight of his life. And this pertains, of course, to the arms deal trial. So the arms deal trial is a case that has been going on and on and on, and it's finally close to the trial phase. And the trial is supposed to start next year. And we are currently at the pre-trial phase, and there are some disputes that are arising at this pre-trial phase. But depending on how those disputes are resolved, that will have a bearing and a determination on everything that plays out. So it's a critical moment for Jacob Zuma. It's a critical moment because next year, whatever happens in this moment will be affected, right? Next year's outcomes will be affected by whatever happens in this moment. But I thought it would be important for me at this particular point to explain what has been happening today, this concept of a pre-trial and everything that has been happening. A pre-trial hearing in South African law is a critical step in the litigation process. Typically, what you have is a conference between the legal teams, and they discuss various issues which I'm going to go through. But sometimes you have an even more formal process like what you saw today because the parties have material differences. But let's just go through the pre-trial process in and of itself and why it matters. The pre-trial process allows parties to discuss and streamline trial procedures, to resolve disputes, and to clarify issues before the trial begins. This process is governed by the uniform rules of the court, and the pre-trial conference, which is typically what happens, focuses on case assessment, procedural clarity, and you try to solve potential disputes that could arise. So Uniform Rule 37 and the related provisions of the practice manual and directives require parties to constructively engage with each other in pre-trial proceedings to narrow the issues that remain in dispute. Two types of documents are typically produced at the end of this kind of a procedure. One is known as a pre-trial minute, and the other is known as a pre-trial memorandum. I'll discuss each of these. So parties prepare a pre-trial memorandum outlining their positions, and the process may involve a judge sometimes, right? Ultimately, the whole reason why these things happen is to enhance the efficiency and focus during a trial, right? So what is the role of the judge? The role of the judge is the one of making sure they get to the point where the trial happens without any glitches. So in South African law, the judge plays an active role in pretrial conferences to ensure the efficient conduct of the trial. The key aspects of the judge's role include three major things. Number one, calling the conference. A judge who does not need to be a trial judge to be the trial judge may call upon the attorneys or the advocates for the parties to hold or to continue a pretrial conference before the judge in chambers. The judge can direct a party to be available personally at such a conference. A pretrial hearing arises from difficulties, right, which is different from the conference, in concluding issues between the parties. Right. So the first thing is that the role of the judge is calling the conference. Number two, providing directions. With the consent of the parties, the judge may give any direction at the conference or thereafter, which might promote the effective conclusion of the matter. The judge may furnish such directions or direct that an interlocutory application be brought. Right? And the third role of the judge is overseeing the process. The judge must hold a final pretrial conference at which the parties must table a joint proposed final pretrial order. The judge is responsible for ensuring the legal representatives behave seemingly and comply with the prescribed procedure. However, the judge's role is limited to providing directions and oversight. The judge cannot go beyond this by, for example, putting questions to witnesses in the form of cross-examination or calling witnesses not called by the parties. The parties remain in control of taking evidence during the trial. Okay, so the role of the judge is limited. So what happens in the preparation of this document that I called the pretrial minutes? Pretrial minutes are typically prepared through the following process. Number one, a pretrial conference. The attorneys for both parties meet to discuss and agree on various procedural matters before the trial. This meeting is known as the pretrial conference. Then there's the drafting of the minute. After the pretrial conference, attorneys draft a document summarizing the outcomes of the meeting. This document is known as the pretrial minute. The contents of the minute. The pretrial minute typically includes the following: admissions of fact, simplification of the issues, potential settlements, and further steps to be taken in the case. After this third step, or just like the third thing I want to talk about, the contents of the minute. The fourth thing, signing of the minute. For the pretrial minute to be complete, it must be signed by both attorneys. If one attorney does not cooperate, the other attorney can still draft the minute and explain their attempts to get the other party to sign it. So as you saw at this particular pretrial hearing, the attorney, or the advocate rather for the state, Advocate Billy Downer, tried to let the judge know that he had drafted the pretrial minute, that Advocate Dalimpofu had not participated in that process, and that there were some issues around that, but still he had the minute. Number 5, filing the minute. The signed pretrial minute must be filed with the court before the pretrial hearing. Failure to file the minute may result in the court not entertaining the pretrial hearing. Number 6, the binding nature. The pretrial minute is binding, meaning that parties cannot easily withdraw agreements made during the conference unless special circumstances arise. It serves as a critical tool in litigation to clarify disputes and facilitate resolution. So there are two different documents that I spoke about. One is a pretrial memorandum, the other is a pretrial minute. These are similar documents. The pretrial minute is more binding. Let me talk about the pretrial memorandum as a starting point. The pretrial memorandum, its purpose is typically to outline the issues in dispute, outline the evidence that parties intend to present, any agreements reached prior to trial. Its main goal is to inform the court and streamline the trial process. The content is that it includes summaries of the case, the legal arguments, list of witnesses, documents that will be presented. It serves as a guide for the judge to understand the case better and to facilitate the management of the trial. Its legal status. While it is an important document for trial preparation, it does not carry the same binding contractual weight as the pretrial minute. Now, let's talk about the pretrial minute. The pretrial minute, its purpose is that it's a formal consensual document, consensual being important there, that reflects the agreements made between the parties during the pretrial conference. It outlines what has been settled and what issues remain for trial. Its content, it details specific points of agreement, the issues to be tried, and any any admissions or concessions made by the parties. It may also include procedural agreements regarding the conduct of the trial. The legal status of the pretrial minute. The pretrial minute is considered a binding agreement between the parties akin to a contract. Parties can only resile, or meaning remove themselves from it, under specific circumstances, such as mutual consent, or if special circumstances arise that justify such a withdrawal. So this is where we are. Part of the challenge with the Zuma case as things stand right now is that the status of the prosecutor is one that has been contested by the Zuma team. They've said that they view the prosecutor to be too close to the case, and that will have an impact on whether or not the trial in and of itself is fair. Everyone is entitled to a fair trial. And as things stand right now, they are seeking reasons for why a judgment was made against them for the recusal of this particular prosecutor. And this has been the main thrust of the legal arguments that were made today. I'm going to look at those legal arguments in full and the adjudication by the judge at a later stage. But the purpose of this video was to get you to understand this pre-trial process and where things are in this particular case. We're at the pre-trial stage and we are awaiting the judgment or the decision of the judge on the question of whether or not reasons should be provided for his denial of the recusal of Billy Downer. That has a bearing on the strategies that will be taken by the Zuma legal counsel in moving forward. So I hope this helped you. Till the next episode.